Good morning and welcome to Higgs and Johnson's webinar on the Bahamas Advantage, showcasing recent legislative changes in the Bahamas relating to trusts and also the possibility to form a new vehicle called the executive entity. My name is Heather Thompson and I'll be the moderator this morning. I just wanted to mention that you can put your questions as they occur to you during the presentations by using the chat option. Nothing that is said here today should be taken as legal advice, although we will of course try to be as accurate as possible with the information that we give you. We look forward to your evaluations afterwards as well, because this is our first venture into the cyber world in terms of a webinar. Welcome. I now turn you over to Dr. Earl Cash, who will be speaking about the abolition of the rule against perpetuities and forfeiture clauses. Dr. Cash?
Thank you very much, Heather. At the end of December, 30th December to be precise, 2011, we had the Rule Against Perpetuities Abolition Act 2011 that came into effect. That act abolished the rule against perpetuities, which includes the rule of law prohibiting trusts of excessive duration and restricting the period for income accumulation. And this abolition would occur automatically for dispositions of interest in property made on or after the 30th of December 2011. And the abolition would occur by application to the courts for dispositions of interest in property made before the 30th of December 2011. The idea is that one could not really cause a change in the perpetuity rule in relation to trusts before the act without assistance in most cases of the court. A disposition includes the conferring of a power of appointment and any other disposition of or creation of an interest in or right over property. The trustee can make an application to the Supreme Court for a declaration that the Rule Against Perpetuities Abolition Act 2011 applies to the disposition in trust before the 30th of December 2011, and the trustee will have to prove that the declaration is in the interest of the beneficiaries generally. Our Supreme Court order may stipulate that dispositions which are void by virtue of the application of the rule against perpetuities before 30th December 2011 will remain void. The order may also stipulate that the interests of a person affected by the declaration would be protected or preserved. Section 71, subsection 4 of the Trustee Amendment Act 2011 gives the court the power to extend the perpetuity period up to 150 years from the date of the instrument. This power is applicable where the instrument does not confer an unlimited power to amend. Likewise, Section 3.3 of the Trustee Amendment Act 2011 gives the person the power to amend the trust, that gives the person who has the power to amend the trust instrument the ability to extend the perpetuity period up to 150 years from the date of the trust instrument. The idea in relation to the perpetuities, the Rule Against Perpetuities Abolition Act 2011, is that it is essentially an act that applies to Bahamas trusts or trusts governed by the laws of the Bahamas, and it does not purport to affect the rule or to offend the perpetuity rule that might be applicable in relation to foreign trusts. Another interesting development was an amendment to our Trustee Act, Section 87A, that came into effect also on the 30th of December 2011, that deals with forfeiture clauses or interorum clauses. Such clauses would allow certain beneficiaries to be disenfranchised in relation to the trust if they were to challenge the trust. This new Section 87A of the Trustee Act provides for the termination of the interests of a beneficiary upon the trust being challenged. A trust instrument may provide that the interests of a beneficiary shall terminate either automatically or pursuant to a power conferred in the instrument to terminate it upon the occurrence of any of the following two events. One, where the validity of the trust is challenged in whole or in part in any court within or outside the Bahamas. Or two, where any action is taken to assist, promote, or encourage such a challenge. The term validity of the trust includes any question concerning the validity of any disposition of property to be held upon the trusts of the trust, and any question as to whether any settler of the trust intended to create a trust on the terms of the trust instrument. The challenge of the validity of the trust or the action to assist, promote, or encourage such a challenge will terminate the beneficiary's interests. In one case, whether or not it is brought or taken by the beneficiary, or whether or not it is brought or taken in good faith or with reasonable cause. The termination means that the beneficiary ceases to be an object of a power of appointment or power of advancement, or that the beneficiary ceases to be a member of a class, so that in effect that member would no longer be a member of a class of the beneficiaries. Unless otherwise provided in the trust instrument, no rule of law or equity giving relief against forfeiture shall apply to a no contest clause. The overall effect and value of this legislation is that it now gives statutory effect to our no contest or forfeiture clauses, because up to this point, its effectiveness or validity was not always certain, but with the statute support, we now have clarity and certainty in terms of its effectiveness and its validity. With that, I am pleased to turn you over now to my litigation partner, Leroy Smith, who will give you an address regarding other amendments to the Trustee Act in 2011, specifically focusing on arbitration and court applications in relation thereto.
Hello, good morning. My name is Leroy Smith. I'm a litigation partner here at Higgs & Johnson. As indicated by our Dr. Cash, I will this morning discuss the sections of the Trustee Amendment Act 2011, which have formally introduced trust arbitration into Bahamian law. I will also discuss the provisions of the Perpetuities Abolition Act 2011 insofar as they deal with the making of court applications to eliminate the perpetuity period for existing trusts. Taking first then the Trustee Amendment Act 2011, this statute came into force on 30th December 2011. It made several significant changes and I dare say improvements to the Bahamas' principal trust statute, namely the Trustee Act 1998. One of these changes involves the arbitration of disputes concerning trusts in the Bahamas. I'll discuss this development in greater detail momentarily, but I'd wish to put it in context by posing two questions, namely, one, what is arbitration? Two, what were the pre-existing legislative underpinnings for arbitration in the Bahamas? Taking point one, What is arbitration? While this is a basic question, I couldn't ask you to trust arbitration if I didn't tell you what it was. Arbitration briefly may be defined as, arbitration is one form of ADR, alternative dispute resolution. What it entails is the settlement of a dispute by an arbitrator who is a disinterested or independent person selected by the agreement of the disputing parties and appointed by them to hear and settle their dispute with a decision. During the course of the arbitration, the arbitrator considers evidence and arguments and ultimately arrives at a decision. This decision is known as an award and is generally final and binding on the parties, subject to any previously arranged right of appeal. Second preliminary point, legislative underpinnings. In May of 2010, the Bahamian Parliament passed the Arbitration Act 2009 into law. This piece of legislation was based heavily upon the United Nations Commission on International Trade Law, Model Law on International Commercial Arbitration, 1985. The Arbitration Act 2009 is stated to apply to arbitration agreements, which are in turn defined as meaning agreements between parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, and may be in the form of an arbitration clause in a contract or in the form of a separate agreement. The Arbitration Act 2009 provides a framework for domestic arbitration proceedings, the composition of arbitration tribunals, and the application of laws or rules that will be applied to the arbitration in order to determine the dispute. The Arbitration Act also gives the court wide powers to stay proceedings in Bahamian courts which have been brought in contravention of parties' prior agreement to refer such matters to arbitration. I would also mention that within the Bahamas, there is also the Arbitration Foreign Arbitral Awards Act 2009, but rather than addressing arbitration proceedings in the Bahamas, this instead makes provision for and facilitates the enforcement of awards made in other contracting states, that is to say, states contracting under the New York Convention on Recognition and Enforcement of Arbitral Awards. By and large, the Arbitration Act 2009 contemplates commercial and contractual applications, and in this sense, it represents a significant, I would say, landmark for this jurisdiction. It didn't speak to trusts, however, and while there were arguments that its provisions could be stretched to cover trusts or should be construed as applying to trusts, issues did arise, questions did arise. So, for example, the questions of how beneficiaries who were, in the ordinary course of things, not signatories to a trust instrument, how precisely they could be bound by the arbitration clauses contained in trust instruments. There's also the question of unascertained beneficiaries, etc. The matter is now made crystal clear by the Trustee Amendment Act, to which I speak. This supplies a bespoke solution for arbitration proceedings involving trusts. It achieves this by introducing 4 new sections into the Trustee Act, namely sections 91A through 91C, in addition to introducing a new second schedule into the Bahamian Trustee Act. Section 91A, entitled Arbitration of Trust Disputes, this provides at subsection 2 that where a written trust instrument provides that any dispute or administration question arising between any of the parties in relation to the trust shall be submitted to arbitration, that provision shall, for all purposes under the Arbitration Act, have effect as between those parties as if it were an arbitration agreement and as if those parties were parties to that agreement. I would mention that section 91C is essentially a definitional section. It defines dispute as meaning any difference. It defines administration question as meaning any relief or question in respect of which an action, application, or other reference to the court could have been brought. And finally, the parties in relation to the trust is defined as meaning any trustee, beneficiary, or power holder of or under the trust in their capacity as such. The 2 terms that I've just mentioned there, beneficiary and power holder, also have their own definitions. Beneficiary is defined as including an object of a power, whether or not ascertained or in existence, and a charity. Power holder means any person holding a power in relation to a trust and includes a person in the position of protector. These definitions have been broadly drafted with a view to incorporating all future beneficiaries and other persons who may potentially become parties to or interested in a trust dispute. The Arbitration Act goes on in Section 91A to provide that the Arbitration Act provisions shall be construed according and shall be affected by the new second schedule of the Act. Section 91B is entitled Powers of the Arbitral Tribunal. This provides that arbitral tribunals shall have extensive powers which may be exercised at any stage in trust arbitration. In addition to all other powers of the tribunal, the Amendment Act supplies the tribunal with all powers of the court. These powers include those arising under the Amendment Act or any other statute, also, and very significantly, those arising under the inherent jurisdiction of the court, or otherwise that relate to the administration, execution, or variation of a trust, or the exercise of any power arising under a trust. The Amendment Act also allows the terms of trust instruments to direct the appointment of one or more persons to represent the interests of any persons, including unborn or unascertained beneficiaries, or any class of persons affected by trust arbitration. Where the trust instrument is silent on the point, Section 91B of the Amendment Act supplies the tribunal with powers equivalent to those of the court, including powers enabling it to make representation orders where necessary. The new second schedule of the Trustee Act, as I've mentioned, this essentially states that the Arbitration Act shall be read and construed as if it contained the trust-specific references set forth in the new second schedule. The provisions of the second schedule include paragraph 5, which states that in the case of trust arbitrations, any rule of law or construction treating an arbitration agreement separate from the agreement to which it's part, that rule is disapplied. Paragraph 9 provides that where a person is party to trust arbitration in the capacity of trustee, he shall be entitled to recover his costs incurred in the arbitration from the fund insofar as they're not otherwise available. And this should be the case provided that the tribunal does not find that he has in substance acted for his own benefit, as opposed to acting for the benefit of the fund. This brings me to the end of my discussion of the Arbitration Act. The Trustee Amendment Act. I turn then to consider briefly the Rule Against Perpetuities Abolition Act 2011. This act provides in Section 3 that where, in respect of, as Dr. Cash mentioned, in respect of trusts coming into existence after the Act, the rule against perpetuities is abolished. Now, with respect to existing trusts, it's possible to make application to the court with a view to having the court grant an order disapplying the rule against perpetuities to such trusts. This is a nascent jurisdiction, and the Act doesn't provide regulations in terms of setting out the precise manner in which the application is to be brought, but it states clearly that the application in the first instance must be brought by the trustee by way of petition. This means then that the application will need to be supported by an affidavit, and for the reason that the trustee will be the sole initial party, we consider that full and frank disclosure must be made. The court has the discretion to require notification to other affected parties. Ultimately, the court will be concerned to ensure that the order would only be in the best interest of the trust and its beneficiaries. The court will also be concerned to ensure that the order will not interfere with the past or otherwise retroactively impose hardship on other persons. And this brings me to a close of my presentation. I'll now hand you over to R. Gillian Chase Jones, Senior Associate, who will speak to directed investments.
Thank you, Leroy. In this portion of the Higgs and Johnson webinar, I will be examining Section 81A of the Trustee Amendment Act 2011, which deals with directed trusts. Prior to the Trustee Amendment Act 2011 being brought into force, Section 81 of the Trustee Act enables a settlor and trustee to agree to include into the trust instrument provisions that allow certain powers and discretions normally exercisable by the trustee to be conferred on a third party, usually the settlor protector. For example, the power to remove and appoint trustees, or the power to add persons to the class of beneficiaries, or the power to exclude persons from becoming beneficiaries of the trust. It should be noted that while such third party was able to exercise certain powers under the trust, Section 81.3 of the Trustee Act made it clear that the third party was not deemed to be a trustee merely by the exercise of such powers, nor was such third party liable to the beneficiaries of the trust if the powers granted were exercised in good faith. As a result, while Section 81.2 of the Trustee Act provided the legislative authority for the conferring of trustee powers on third parties, the question of the residual liability of the trustee as a fiduciary for any losses to the trust assets remained. Essentially, the trustee would be liable to its beneficiaries for acting on the directions of a third party. This led to concerns regarding the extent of the trustee's duty to monitor, oversee, or intervene in any directions of a third party to avoid liability for any potential losses in relation to the trust assets. In response to concerns from both corporate trustees and settlors, Section 81A has been inserted into the Trustee Act and enables trustees to meet the desires of their clients, that is, a trust structure with investments of its assets managed or directed by a trusted advisor or family member, without leaving the trustee with the residual responsibility of ensuring that directions make sense to the trust assets as a whole. So what is a directed trust? A directed trust is one in which the investment power over trust assets is exercised by the trustee as and when directed by another person, be it the settlor or the protector or some other third party. For the purposes of this section, such person is termed the power holder. Other key definitions in this section are investment power and direction. Investment power means any power vested in the trustees relating to the management or investment of the trust property, and without prejudice to the generality of the foregoing, includes any power to acquire or borrow property, alienate or lend trust property, engage or appoint custodians, investment advisors, and investment managers, and to terminate their appointments, exercise any right or power attaching to any trust property, including any power to vote or pass resolutions as a member of a company or holder of any security in a company or a partner of any partnership, and the power to delegate any of these powers. Direction, as used in this section, means an instruction given to the trustee to exercise the investment power, which is in the form provided for in the trust instrument and which the trustee believes has been given by the power holder, and where more than one person comprises the power holder by such one or more of them as the trust instrument specifies. In order for Section 81A to apply, the trust instrument must expressly provide that an investment power is exercisable by the trustee as and when directed by the power holder. In the absence of a direction from the power holder, the investment power shall not be exercised, and that Section 81A applies to the investment power. Section 81A2 provides the statutory protection for a trustee in relation to directed trusts. Where the appropriate language has been included in the trust instrument, the trustee will not be liable for any loss arising by virtue or in consequence of the trustee acting in accordance with a direction from a power holder, upon receipt of a direction from a power holder, failing to do anything other than act in accordance with the direction, or failing to do anything in the absence of a direction from a power holder. And no duty shall be owed to the trustees giving rise to any such liability. Section 81A3 provides that subsection 81A2 shall not apply to anything done or not done contrary to an order of the court. And Section 81A5 provides that a direction will not be considered a direction, where it can be shown that at the time the trustee acted upon the direction, it had actual knowledge, and this is without requiring the trustee to make any inquiry or investigation, that the direction had been given dishonestly, that is direct and clear knowledge, not suspicion. The overall effect of this section is to afford trustees statutory protection in relation to trust, where the investment powers are directed by a third party. I will now turn you over to Nadia Taylor, another senior associate with the firm, and she will be speaking on executive entities.
Thank you, Jillian. Good morning, ladies and gentlemen. This morning I will be introducing you to the be-all and end-all, the Bahamas Executive Entity, which is the newest item in the Wealth Management Toolkit of structures available in the Bahamas. Throughout the presentation, I'll be referring to the Bahamas Executive Entity as the B. The B may be performed pursuant to the Executive Entities Act 2011, which I'll refer to as the Act, which came into force in the Bahamas on the 1st of February of this year. Practitioners in the Bahamas, working along with the Bahamas Financial Services Board and London law firm Lawrence Graham, assessed several of the structures already in place and came to the conclusion that there was a need for a unique structure, one that could carry out executive functions, and thus the idea for the B was born. Over the years, the working group set about designing the B as a solution for an area of need. In an attempt to explain what it is, we could say that the bee looks like a wasp, sounds like a hornet, but stings like a bee. Making that analogous to wealth management tools, it would look like a foundation. Structurally, it has a charter, acts a lot like a company with governing body, officers, but really it's a unique structure. Now, what makes the bee unique may be found in the Act. The Act defines the bee as a legal person established by a charter to perform only executive functions. The Act defines executive functions as any powers and duties of an executive, administrative, supervisory, fiduciary, and office-holding nature. Also, executive functions can be the ownership, management, and holding of executive entity assets and trust assets. It should be noted that the B currently cannot be used to act as a trustee, as there are certain other areas of legislation that would have to be amended to make this permissible, and this has not taken place as yet. So currently, the B can really only be used to carry out executive functions or to act in a shareholding capacity. The advantages of the B are quite numerous. Primarily, it fills a gap in the wealth management toolkit. The B assets are defined in the Act as limited to only assets reasonably required by the B to carry out its executive functions. The limited liability characteristic would be very attractive for those individuals interested in utilizing the B to carry out executive functions, like those of a protector or director. Additionally, the B may be utilized as an internal governance tool, which may be beneficial in connection with training or succession of family members in connection with shares of a company. By way of example, where a B is utilized to hold the shares of a private trust company or a family business, there would be no succession issues if the B is the holder of those shares, and the Charter can stipulate how the rights and obligations in connection with the shares should be handled. The fact that the B has no shareholders allows for privacy and continuity of ownership. Additionally, the Act provides that the B may have limited or perpetual existence, which may be beneficial depending on its purposes. The Act provides some examples of functions that a B may take, which are not exhaustive. So, for example, the B can be used to act as an enforcer, protector, trustee, investment advisor, the holder of an office of any trust. So, for example, if a trust provides for a family or advisory council, the person's acting in that capacity can do so utilizing a B, or a legal person. So, a company director, a person acting as director can do so utilizing a B. Some notable characteristics of the B that may help to understand the structure and its benefits are that it's a legal person established by a charter to perform only executive functions, it's resident and domiciled in the Bahamas, able to sue and be sued in its own name, that it has limited liability, there'd be no minimum number of assets required. As I explained earlier, the assets held by the B would only be those necessary to carry out its executive functions. It can be established for a definite or indefinite period, would only be performing those executive functions, and it doesn't have beneficiaries. Naturally, as with anything new, there will be questions and concerns. We've taken you on a tour of the pros, so now we could look up some of the potential or perceived cons. Now, there may be concern for the potential abuse of the vehicle by the governing body. So, for example, the governing body utilizing a B for money laundering purposes or the money laundering vehicle. This becomes a greater concern where this type of vehicle doesn't have beneficiaries. So the question arises of who can enforce the obligations of the governing body under the Charter. Also, a potential concern may arise where whether the structure would be recognized outside the Bahamas by other jurisdictions. And also there may be a question of portability. Can the structure be continued to another jurisdiction? The concerns mentioned above have been thoroughly considered, and we would respond as follows. With respect to the potential for abuse, ultimately a court can enforce the obligations of the governing body set out in the Charter. So notwithstanding the absence of the beneficiaries, there would be some accountability for actions of the governing body. The B would also be very unattractive as a structure to use for money laundering purposes, as the Act specifically restricts or expressly restricts the amount of assets that can be held. Additionally, with respect to the money laundering concerns, a B can only provide executive functions to vehicles listed in countries on the first schedule to the Financial Transactions Reporting Act 2000, which would be countries with similar anti-money laundering legislation to the Bahamas. Notably also, every B must have an executive entity agent, which provides regulation of the B, pretty much ensuring that all relevant anti-money laundering and countering the financing of terrorism requirements are being met under Bahamian law. Additionally, depending on its purpose, the B may be subject to more rigorous regulation. If the B is acting as trustee, for example, it would be likely be subject to a higher regulatory standard. Further, the Charter can be drafted to build in protections, such as the inclusion of a protector to regulate the governing body of the B, and concerns whether a foreign court would not recognize a B may be subdued by general principles of comity, just as a Bahamian court would recognize a creature of statute pursuant to the governing law of another jurisdiction. The same would apply. Now, portability would not be an option now, as the Bahamas is the pioneering jurisdiction, being the first to introduce this type of structure. It may be in the future, when other jurisdictions catch us up, that that will be an opportunity or reality for continuation. But the question for now that should be considered is whether portability is required or desirable in determining whether you want to use a B. Now, some conclusions. The reason for concerns with a newer product or service offering is understandable. However, in the development and creation of the B, there has been a significant effort to ensure that both enforceability and accountability have been considered in drafting the legislation. The Bahamas is the first and only jurisdiction to develop and implement a structure of this type, and naturally there will be persons who are skeptical. However, the product has been developed as a result of demand. With that said, and as we begin to implement this new structure, we'll do so taking into account any concerns raised, and of course the Act can always be amended to take into account any issues that may arise. Naturally, any clients interested in utilizing the structure will have to ensure that all relevant tax considerations will be taken into account. Notably, though, B is exempt from any business license fee and thus carrying on business in the Bahamas. It would also be exempt from income tax, capital gains tax, or any tax on income or distributions accruing to or derived from the B or in connection with any transaction to which the B is a party. The regulations which accompany the Act additionally provide that a certificate of tax exemption can be obtained from the Registrar of Executive Entities, certifying that the B is exempt from taxes. In conclusion, acceptance comes with understanding. I hope that this presentation has been helpful in giving you all a better understanding of what a B is and the ways it may be used. Hopefully this will lead to a greater acceptance and use of this new structure. I will now pass the mic back over to our moderator, Heather Thompson, who will facilitate a question and answer period.
Thank you, Nadia. I see that none of our participants have put through any questions through the chat option as yet, so I'll have to come up with some of my own. My first question is really for Dr. Earl Cash, and that question is, if you have a trust which was originally created under law other than that of the Bahamas, and that trust migrates to the Bahamas, it has a power of amendment. Would it be possible to use that power of amendment in order to increase the perpetuity period of the trust, which, say, let's assume it had a perpetuity period of 100 years. Would it be possible to increase that perpetuity period to 150 years from the date that it was created using the power of amendment?
That's a very intriguing question, Heather. The view is that the abolition, the Rule Against Perpetuities Abolition Act 2011 tends to deal with trusts established in the Bahamas, governed by Bahamas law, whether before or after the date of that the act went into effect, that is on the 30th of December 2011. So if you had a trust migrating from another jurisdiction, the intent is that we would not try to offend the rule that was established, that applied to that trust when it was initially established. So if in this instance you had a trust established in that jurisdiction and the perpetuity period was 100 years, and subsequently that trust migrated to the Bahamas, and although under our law, the person with the power to amend the trust could amend the period so that it would now extend to 150, that would not be permissible by virtue of amendment, because that would be literally offending the rule that applied, the 100-year rule that applied when the trust was initially established. Of course, on the other hand, nothing would prevent the trustee from going to our courts under Section 3.3 application under the Trustee Act to get the court's permission or order, to get the court to order an amendment in that respect. But at least with that approach being taken, the court would then give consideration to all the beneficiaries and whether the interests of those beneficiaries would be adversely impacted by such an order. But the short answer is that by amendment itself, it's not likely that the settlor or whoever has the amending power could amend that trust to extend the perpetuity period, which was applicable when the trust was initially established in another jurisdiction.
Thank you for that thorough response. A question now for Leroy Smith. Leroy, we hear all of this, talk about arbitration. What do you think are the benefits of arbitration as compared to litigation?
Okay, thank you, Heather. Well, insofar as it concerns litigation, obviously, I think a great deal of it. It's of ancient pedigree, and speaking very frankly, we're quite good at it. That being said, when advising clients who are contemplating embarking upon that path, the path of litigation, one of the things that we always advise at the outset is that once you start, litigation takes on a life of its own. There's no way of guaranteeing any number of things. The amount of time that the litigation will take, the cost. It's possible to make informed estimates, but again, these are just estimates. Litigation takes on a life of its own. So it's for that reason that we also consider that it's useful in many instances to look to other forms of AD, to look to ADR as a potential alternative for the resolution of disputes. And ADR, of course, encompasses arbitration, also mediation, expert determination of disputes, etc. With respect to arbitration specifically, it brings the benefits that I've alluded to, namely that it enables the parties to the arbitration to exercise a form of control over the process. This inures to their benefit insofar as it enables them to control or have a greater amount of input with respect to the length of time the process will take. It also assists in enabling the parties to control the amount of the cost. Another benefit is the fact that arbitration in the ordinary course of things will be confidential. So, for example, in the trust contest text especially, whereas litigation will be in the ordinary course of things held or tried in open court, an arbitration can be done, the entire dispute can be ventilated and resolved behind closed doors. And assuming that the parties have stipulated for it, in their arbitration agreement, the result will remain confidential for all times. Another aspect of arbitration is the fact that the award, the ultimate result, can be final. Again, the entire arbitration process will flow from what the parties have agreed, but usually we expect to see a situation in our arbitration agreements whereby the dispute of the arbitrator is final with no right to appeal therefrom. In the litigation context within the Bahamas, there is a court of first instance, which is the Supreme Court. It is possible for parties an aggrieved party, an unsuccessful party, to make an appeal to the Court of Appeal, which is the Bahamas' highest appellate court. But from there, it is possible to make a further appeal to the Privy Council. This, in many instances, may be time and cost intensive. So, in summary, then, confidentiality, the amount of time, the amount of cost, and the finality which come from arbitration are things which can, in many instances, cause it to be an attractive option for participants.
Yes. This is Heather Thompson once again. I think another advantage of arbitration that Leroy didn't focus on is that you would have the ability to retain arbitrators who have specialist knowledge and trust. In many of our offshore jurisdictions, we often hear the complaint that judges are too often generalists. So I suppose that would be one way to address that particular question. Now, we always save the difficult ones for the ladies. Jillian, this directed trust legislation sounds wonderful, but what about a trustee who is in a situation where he is receiving directions and acting on them, and the value of the trust fund is just dissipating slowly but surely, or even rapidly? Can the trustee just sit back and do nothing? What's your view on that?
Thank you, Heather. When looking at this section, I think the whole purpose of the directed trust legislation was as a means to shift the responsibility from the trustee to whomever that third party is. So I mean, strictly speaking, if your trust instrument provides for the directed trust mechanism to work, you know, once those instructions are being given validly, there is no dishonesty, you don't have any actual knowledge of that, then technically you should follow those directions.
Okay, so trustees, here's an opportunity for you to be bold and go where no one has gone before. Nadia, executive entities sound wonderful. Are they costly?
In relation to the cost of an executive entity, it is similar in pricing to a foundation. The annual fees are about $500 per annum. However, the rate does increase based on the time of the payment. So if it's paid within the first quarter, then it's $500, and the fee accelerates from there. It goes up, I believe, to $700. I'll look at the schedule and give you the fees now. Yes, it goes up to $550 if it's paid after October 31st. After April 30th, and up to October 31st, and then after October 31st, it goes up to $750 annually. So there's encouragement to pay your annual fees early. Also, with respect to the initial setup of the executive entity, the fee would be $550 for the first quarter of the calendar year, and actually is reduced if it's established later in the year. So the fees are fairly reasonable. Now, there would also be a fee for the executive entity agent, which would vary based on the service provider that you would be using.
Okay, well, I'd like to thank our speakers for their valuable contributions, and I hope that you all found it useful as well. Please don't forget to send in your evaluations, and we'd all like to thank you for your attention. Thank you and goodbye.